8 o'clock on the nose. Thanks for coming, everybody. I'm alone tonight, so bear with me. It's going to take a bit to get through all this. We're going to get into the law, and I'm going to try to bring it down so that everybody can understand it. Episode 6, Standing Doctrine. Next stop, SCOTUS, Supreme Court of the United States, and review of mass DPH hearing. I will not do that tonight. I don't have time. I don't want to be here for 4 hours. It would take too long. So we're going to defer the mass DPH hearing until next week, or maybe I'll do it with some people who want to do it with me. And we will, in a group, review the hearing from the Massachusetts Department of Public Health Commissioner, Robbie Goldberg, I believe his name is. So let's get right into it. I'm only going to do the top half of this agenda, which is I'm going to say what happened recently with my case. I'm going to go over the facts, the procedural history in the U.S. District Court and the First Circuit Court of Appeals. And then I will move to talking about the right of petition. I'm going to go through the history of it. It may be boring, but it's really important to understand. Okay. And we're going to end that with the First Amendment to the U.S. Constitution and where it's derived from. So then, where does the authority of standing doctrine come from? Like the courts can't just do stuff. They have to have authority to do it. The courts were formed by Article 3 of the Constitution, the legislative body, and then the executive, and then the Article 3 is the courts. And it says what they have jurisdiction over. And that's the federal courts, don't forget, because it's the Constitution. So it's not talking about states. The state courts are for basically everything else, everything that's not a constitutional question or federal question. If you claim something like your constitutional rights are being violated, or if you claim that your Title VII rights, like religious discrimination happened, that's a federal law, Title VII. So if you mention that, you can get into federal court. Or if you do have a contract dispute, but the other party is in a different state, it's called being diverse. You're in diverse states, and then you can get into federal court. So those are the basically two ways. It's either federal or constitutional law that's being disputed. It's at the crux of the dispute, or you're in different states. If those two things aren't happening, they're going to throw you out of federal court and say, go back to state court. That's where you belong. And I'm going to mention that at the very end, because I forgot to actually put that in here. So I threw a few notes on a slide. Hopefully I'll get to it. So I'm going to talk about the pathway to standing doctrine. I'll talk about matters at law versus matters in equity. That's important to understanding all this. And then I'll go through a management systems analysis of what happened in the United States with all the cases that were like most popular, most cited, and then just the sheer number of civil litigation cases brought in the district courts for the past 30 years. And you're going to see a big signal. So I'll go through the case citation rates, caseload changes over 30 years, organizational behavior, and then I'll probably end right there. So let's go. What happened recently? Well, I'm going to write a petition for writ of certiorari, or certiorari, as I would say. C's were always pronounced as K's. They were never pronounced as S's in Latin. So when we say certiorari, or, when I say, there's a funny thing, pro hac vice, when a lawyer's coming in for another lawyer, and you got to have a lawyer who's barred in that state, they're coming in pro hac vice. I've been corrected. It's not vice, it's vice. I'm like, yeah, okay, whatever. You can speak Italian if you want. It's Latin. It should be vice. So much for really understanding Latin. I don't know who does, but it's not vice, it's vice. 2024, February 15. So that's a year and a half ago. I paid $600 to appeal my dismissed case. And then a year and a half later, or 17 months later, I called to ask the status. Said, I haven't heard from you guys in almost a year and a half, 18 months. What's the status? Do I need to do anything? And they said, oh, no, you don't need to do anything. We just haven't gotten to it. Okay, now this is normal. And a week later, they affirmed my dismissal. And let me show you what they gave me. I waited a year and a half to get this, for them to even look at it. Did they look at it? No, I don't think they even looked at it. Per the allegations, I'm going to read it because it's only 2 paragraphs. This is paragraph 1. This is the entire decision in my case. Per the allegations set out in the complaint filed in the U.S. District Court for the District of Massachusetts, plaintiff appellant John Paul Beaudoin Sr. was a student at Massachusetts School of Law. He completed 1 year of study, but after refusing to comply with the school's requirement for COVID vaccination, he was removed from the student body. Beaudoin sued the Massachusetts governor and other officials on the theory that the state had disseminated grossly flawed information about COVID-19 and the vaccines against it. On this basis, he alleged that the officials were responsible for Massachusetts law school's decision to adopt a vaccine mandate and for the termination of his studies due to his noncompliance with that mandate. His request for remedies included a statewide halt to COVID-19 vaccination, pending expert review, and a mandatory announcement across all available news media that the government had disseminated fraudulent pandemic information. I like the way they say, after refusing to comply with the school's requirement for COVID-19 vaccination. That's true, but they seem to be slanting like I must be crazy for not complying. Yeah, I mean, it says governor and other officials. So that was the medical examiners, the 4 of them. The 5th one is the chief medical examiner of Massachusetts, and then the public health commissioner. All right, paragraph 2. And here's where they put in so much effort to read all the material, especially after a year and a half when I called them up. And they put in just so much effort. I really appreciate all the effort they put in. The district court concluded that dismissal was in order because Beaudoin had failed to offer allegations sufficient to establish Article 3 standing to sue. So remember that, Article 3 standing. The word standing doesn't exist in Article 3, but they call it Article 3 standing. And I'm going to show you how they derive that. I'll just say it's attenuated. This is a quote, that Article 3 standing is a constitutional precondition that's made up to a federal court's power to adjudicate a case. It is plaintiff's burden to allege sufficient facts to plausibly demonstrate standing. We have carefully considered each of the arguments offered by Beaudoin. Sure, they really carefully considered it, because now they're just starting to say what they actually did, right? And we're almost at the end. We have carefully considered each of the arguments offered by Beaudoin in briefing and conclude that he has failed to identify any infirmity in the district court standing reasoning. We reviewed de novo, newly reviewed the whole case, the whole decision. They reviewed the whole thing. I mean, I don't know how many pages it is. I think it's 15 pages or something. They reviewed the whole thing newly at the First Circuit, right? That's it. I mean, and they affirmed the decision. In other words, they put in zero effort. They didn't do anything for a year and a half. And when I called them up, they pulled the file and said, oh yeah, we got to get rid of this. It's almost a year and a half. And a week before the 18-month mark, less than a week before the 18-month mark, they affirmed the decision and didn't put any effort in and just wrote it. That's it. They probably read the last paragraph of the decision from the district court. After I paid $600, I got maybe 15 minutes worth of work out of a clerk. But that's not the point. The point is, legally, I have standing. There's no question about it. They just don't want to hear the case, because if they hear the case with all the evidence that I have in Exhibit F, even from 3 years ago, the vaccine narrative explodes. Just poof, gone. It's gone. Both the COVID narrative that goes away too because of all the fraudulent overcounting. So let's review the facts of the case. I know it looks messy. I know, but I'm going to go through here and explain it. And there's a reason why everything's like all kind of like tan there that dominate the graphs. So let's just start in August. I applied to the law school, Massachusetts School of Law. They go by MS Law. That's over on the left side. I wrote to the director of admissions. I said, I'm not taking the vax. Do you have an exemption? He wrote back, it won't be required for you. You're over 30 years old. Don't worry about it. Nobody's going to ask you about it. He wrote that to me. So I matriculated. That's the green bar here. That's the year of August 2020 to May of 21. And what happened in that time? Well, the vaccine came out in January. Well, really December, but January of 21, and Solomon Kizito was 60 years old. He died from the vaccine. He was certified as having died from the vaccine, and he was coded with Y59.0, which means death from viral vaccines. And then a few weeks later, roughly 4 weeks later, Martha was 84. She died. It says it in her death record. She died from the vaccine. It does not contain Y59.0 because the CDC probably deleted it when it came out. And then Doris died 6 days after Martha. Doris was 85. She was certified as having died from the vaccine, but no, it's not coded with Y59.0. Then Diane died 4 weeks after her from a stroke. It says she died from the vaccine. In fact, it's acute intracranial hemorrhage in the setting of thrombocytopenia in a person recently vaccinated. It's not coded, but it says she died from the vaccine in her record. And then Brianna died. Now, Brianna died April 15, 2021, at 30 years old. If anybody's heard me talk before, you know that she died from an ischemic stroke, and she reacted in hours to the vaccine. And they said she died from COVID. And that's why at the very bottom here, it says not certified and no Y59.0. And it says 2024, certified and Y59.0. Why? Because more than 3 years after she died, they corrected the record and added the vaccine to it. They can't get around this. Now, bear in mind, I'm going to law school all this time. And Brianna was 5 miles away from the law school that I went to that imposed, well, I'll get to that in a second. So Joanne also died. She was 59. It says she died from the vaccine. No, it's not certified Y59.0. Excuse me. No, it is certified, but it does not contain Y59.0. Richard was 60, May of 2018. He died. But right around that time, the school instituted a vaccine mandate for the fall semester. So that's another fact in the case. I'm reviewing the facts in the case. Right after I applied for the religious exemption, that was between Brianna's death in April and Eden, who was 17 years old, also died from a stroke from the vaccine. Between those two times, I applied for a religious exemption. So what you see here is 1, 2, 3, 4, 5, 6, 7. 7 people already dead in Massachusetts alone, known by medical examiners. They only put 1 on the death record, and that was Solomon Kizito. Excuse me, they put all these on the death record, but they didn't code them. And that's the only way that anybody looking at data can track who died from vaccines. So only 1 was coded. So you have 7 dead people in the first few months of the vaccine that are being hidden. And you have a vaccine mandate from the school, and you have me applying for the vaccine mandate in June of 21. And then from June to August, I called and I emailed and I called and I emailed, and they just kept saying, oh, he's not back yet. He hasn't looked at him. Oh, he's back from vacation, but he's just looking at him now. Oh, he'll decide in the next few days. And then they just went silent. They went silent for, I think it was over a month. They just didn't return calls, didn't return emails. They unenrolled me from the school. I got a letter in the mail, and it said, start paying back your loan. And I'm no longer matriculating, and they won't let me on campus because I'm not vaccinated. And they never ruled on my exemption, because I did that exemption in June. I even had to go to a notary public, have it notarized. They just ignored it. They ruled on other people's, not mine. So I have a separate lawsuit against the school. Remember, this one is against the governor and health commissioner and so forth. So then after that, Charles was 48, died later that year in November. Not certified, doesn't say Y590, but we know he died from the vaccine. I've talked to friends of the family. And then Cassidy, 7 years old. She's chapter 1 of my book. Reacted 5 minutes, died in a few days. 7 years old from the vaccine. So then in August 22, so we're a whole year later. The whole year has gone by after I left the school. They didn't let me in, right? Then I sued him. I had a window of time I had to sue in. So I think it was a year. So as the governor, the health commissioner, 5 medical examiners in U.S. District Court. I'm going to review the procedural history. What I mean by that is you file something, and then you have to go through a motion to dismiss, and then an opposition memorandum, and a reply brief, and maybe you amend your complaint. So we're starting where the other one left off. August 22, 2022, I filed suit in U.S. District Court. 7 days later, 12-year-old Maya McDonough Rocha died from a cerebellar tonsillar and bilateral uncal herniation stroke from the vaccine. Was it specifically the COVID vaccine? Well, I don't think they looked, but she got 4 vaccines that day. The meningococcal, Tdap, HPV, and her 3rd COVID shot. So if it wasn't one, it was another. But she got 4 shots on August 3rd, and she died on August 29. After going through the whole headache route and degrading over time. A few months later, in December, the defendants, that's the state, they filed a motion to dismiss and also in December, December 3rd. So December 2nd, they filed the motion to dismiss. The day after they filed that, Ian Shoemaker was 11 years old. He had gotten his injections a few days earlier in late November, had heart problems or pain, and went to the hospital. He died. They tried to donate his heart, but they couldn't use it because it was full of clots from the vaccine. I don't have any proof about Lainey Ladd. She was 6 years old, who died. There's a lot of missing information in the file. By the death record, it makes no sense at all. It had to be the vaccine. But I put it in here because it's pretty serious. And how does a healthy 6-year-old girl die and nobody does an investigation? The only time you don't do an investigation is if you want to hide what she died from. And then Ronald died in January, a month later. He was 87. He is certified as having died from the vaccine. In his death record, it says so. But of course, it doesn't say Y590. So what happened in all this time? In December, they did the motion to dismiss. Excuse me. I amended my complaint after their motion to dismiss. So I didn't do a opposition memorandum. I just did an amended complaint. So I amended my complaint and submitted it January 3rd, 2023. The motion to dismiss came after that. It was March. No, it's February, because it was within 30 days. So it was February of 23, they submitted the motion to dismiss. And then I did an opposition memorandum. So the case was dismissed. This is the important part up top here. I don't know if you can see my arrow. The case was dismissed on October 27, 2023, U.S. District Court. So I filed my notice of appeal within 30 days on the 30th day, always last minute, right? And then I filed my appellant's opening brief. So you have to file a brief, stating your case as to why you think it should be overturned. And I waited, and I waited. And this is February of 24. Notice of appeal on, I filed motions to extend time. That's what I did between November and February. So I finally filed it in February. And then you have this big space here. Like, what's happening? That's the year and a half. And then I just told you earlier, August 11th, the judgment was dismissed. It was affirmed. The dismissal was affirmed. Meanwhile, down in the bottom right here, you see this is acute renal failure, sudden kidney failure. There's 4,000 excess deaths. While I'm waiting all this time to be heard, 4,000 dead people. Hundreds under 44. It's not all old people, not like COVID. Now let's get into the history, and this might be a module. I may cut this out as a module and post it, because this is the history of the right to petition for a redress of grievances, like is in the First Amendment. And if people have heard me talk, they've heard me say it's the most foundational right we have. It's the right that upholds all the other rights, because if your other rights are infringed upon, where are you going to go? You go to the courts and you say, stop this guy from infringing on my right of free speech or assembly or religion. In 1215, I'm not going to go back further than that, okay? I'm not going back further than 1215. June 15th, 1215, to be specific, Magna Carta. To no one will we deny or delay right or justice. King John and the barons had this agreement, the Magna Carta, and they agreed that people could petition the king, and the king can't throw them in jail just for complaining about, you can't just, if you complain about your taxes, you can't just get thrown in jail. You have the right to speak up and say, I think you're charging us too much, dude. So after that, let's go jump up 400 years, and we see 1628, the right of petition, June 7th, 1628. Quote, and that your majesty would be pleased to allow petitioning to have redress of their just grievances. Yeah, it's pretty close to our constitutional amendment there, Amendment 1, last line. Petition, redress, grievances, right? Majesty would be pleased to allow. In other words, the king is allowing you to petition the government, the king, because it's a monarchy. At that time, I don't think the parliamentary monarchy was there yet. I think it was 50 years later. It was the lords and barons, I think the barons who owned land, right? Between them and the king, they're making an agreement. Otherwise, the barons would rise up against the king and kill him. So you got to agree at some point. 1689, the Bill of Rights. It's not our Bill of Rights. This is the English Bill of Rights, 1689. That it is the right of the subjects to petition the king, and all prosecutions for such petitioning are illegal. They're saying the prosecutions for petitioning are illegal. In other words, it's illegal for the king to prosecute somebody who petitions him. In other words, you have the right to petition. There it is, 1689 in the Bill of Rights of England. 1748, Montesquieu. I believe Montesquieu gave us the three branches of government that we have. Okay, he was a French guy, Baron de Montesquieu, and he came up with that structure that we now have. He was more, people talk about John Locke a lot, but Montesquieu had more of a hand in forming our government than Locke did. Quote, in a true state of liberty, one man does not have to fear another, but all must fear the abuse of power. That's from the Spirit of the Laws, Book 6, Chapter 6. John Adams in 1776, quote, the people have a right to petition for redress of grievances, as this is essential to the security of their liberties. He wrote that in Thoughts on Government. The people have a right to petition for redress of grievances. It's essential for the security of our liberties. We don't have liberty. The government will tyrannize us unless we assert ourselves to petition against their tyranny for the grievance that we're suffering against the government. And George Mason, the same year, in the Virginia Declaration of Rights, Section 13, wrote that the people have a right to petition their representatives for redress of grievances and to obtain justice without delay. 4 years later, Adams wrote in the Massachusetts Constitution, Part 1, Article 19, and by the way, the U.S. Constitution was modeled after the Massachusetts Constitution. The people have a right to request, by the way of petitions, redress of the wrongs done them and of the grievances they suffer. And here we go, the last one of this section, this history of 574 years, almost 600 years. James Madison and others, mostly James Madison, but I mean, it can't really be James Madison, right? Because I already read you stuff, 300 years earlier, or 100 years earlier, that almost says the exact same words. So was it Madison? No, these guys, they weren't geniuses. They were just smart. They were well-read. They followed the law. They followed the English law, and they basically copied a lot of it. They took the best parts of it. So Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. That last part, to petition the government for a redress of grievances, is the last line of the First Amendment of the U.S. Constitution. Now, I'm going to go through a case. This was Borough of Duryea versus Guarnieri. I think that's in Pennsylvania, but it was in U.S. District Court, rose up to the Supreme Court of the United States in 2011. So we have something that's current, right? We're not talking 1789 with the U.S. Constitution, or 1776 with Adams writing stuff, or 1215, the Magna Carta. We're talking 14 years ago. So Justice Kennedy delivered the opinion of the court, among other rights essential to freedom, the First Amendment protects, quote, the right of the people to petition the government for a redress of grievances, close quote. The court's precedents confirm that the petition clause protects the right of individuals to appeal to courts and other forums, fora, established by the government for resolution of legal disputes. The right of access to the courts for redress of wrongs is an aspect of the First Amendment right to petition the government. That's from Shorthand Incorporated versus National Labor Relations Board and so forth. So Kennedy is saying that the petition clause does apply to the courts. A lot of the justices think it only applies to the executive and legislative branches because it says your representatives in some of the stuff I read earlier. So what else does he say? Petitions to the government assume an added dimension when they seek to advance political, social, or other ideas of interest to the community as a whole. That's really important. Petitions to the government assume an added dimension when they seek to advance political or social ideas of interest to the community as a whole. Like You're killing thousands of people in my state and hundreds of thousands of Americans by this vaccine. Can we please have a substantive argument about it in a court of law with evidence? I'm seeking to advance a political, social idea of interest. Wouldn't it be of interest to know whether or not this vaccine is killing people? I have, through my matter that I brought to the court, I have sought to advance political, social idea of interest through the community as a whole. It does have to do with the public interest, and that's very important for later. Petition as a word, a concept, and an essential safeguard of freedom. Okay, petition as an essential safeguard of freedom is of ancient significance in the English law and the Anglo-American legal tradition. The right to petition applied to petitions from nobles to the king, from parliament to the king, and from the people to parliament. Now, here's where it gets tricky. It's parliament to the king, nobles to the king, and the people to parliament. It didn't say people to the king. All right, so some jurists are going to say, they carved it out. The people don't get to actually talk to the king. I'll tell you about that in a second in the history of the courts. And it concerned both discrete personal injuries and great matters of state. He went on, the right to petition traces its origins to the Magna Carta, confirmed its rights to the baron, king. The Magna Carta itself was King John's answer to a petition from the barons. The Petition of Right of 1628 that I just read to you drew upon centuries of tradition and Magna Carta as a model of the parliament to issue a plea or even a demand that the crown refrain from certain actions. So you're petitioning to either plead or demand that the king and his men stop abusing the people. The Petition of Right occupies a place in English constitutional history, superseded in importance, perhaps only by the Magna Carta itself and the Declaration of Rights of 1689. There's something Americans probably haven't heard of called the Glorious Revolution that what I just read, resulted from when they threw the king out. They rose up against the king. They had a revolution. I don't know if Americans know that. And they brought in this guy from Netherlands, William of Orange. And he was like I forget the woman's name. So there's a queen and the king, right? It was William of Orange. I think he married her, and they were queen and king. They co-ruled because she was English, but they threw the king out for abusing the people. You have a right of revolution. You have a duty of revolution when the government's killing your people. It stated, quote, "It is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal." I read you that earlier. More, petitions to the courts and similar bodies can likewise address matters of great public import, provided the means for distinctive contribution of a minority group to the ideas and beliefs of our society. Individuals may also engage in litigation as a vehicle for effective political expression and association. So you have a right to engage in litigation to sue the government as an effective political expression, as well as a means of communicating useful information to the public, which is what I was trying to do. If you saw my lawsuit, I mean, I read to you part of it, or in the decision, they did mention this. They said that I wanted the court to order the governor to broadcast, right, to deliver a message, to declare, and to order them to deliver through the news media the fact that they way overcounted COVID deaths fraudulently and that they were hiding vaccine deaths. So may facilitate the informed public participation that is a cornerstone of democratic society. So litigation on matters of public concern, which I think this is, may facilitate the informed public participation that is a cornerstone of democratic society. Justice Kennedy, only 14 years ago, is talking about exactly what I'm doing. I mean, everything he's talking about is my case. Petitions may, quote, allow the public airing of disputed facts. Okay, if they want to dispute the facts, they can do that in court. They can bring Janice Gravetti and Robert Weldon and Julie Hull and Mindy Hull and Michelle Matthews, medical examiners who lied on death records. Or they can say, no, we told the truth on it. Oh, he really did die in a car accident with COVID. He was so sick from COVID, he was on the phone talking to his wife, and he passed out and crashed from COVID. That's why he died in the car. They want to come and say that. Fine. Come and say that. Don't hide behind, oh, you don't have standing. You don't have standing. Remember earlier I said some people don't believe that the right to petition applies to, the people. I said there's a carve out there. Are lawsuits petitions? So Scalia and Thomas don't believe they are. Because most of the petition of right, the prose, the words that are used only includes Parliament and the king, not the courts. So I would say to that, the monarchy did not have three branches of government. That's the United States. The monarchy, everybody reported to the king, especially before they had the parliament. The king was it. He was all three branches. So when you petition the king, you arrive at the king's bench, which is the courts. No one can deny that the intention of petition of right was to challenge a government wrong against a person or against the people. That's what the petition of right is, or the right to petition is. You can say it either way, by the way. To interpret the petition clause in any other way is a reach to impose faux opposition in a mock debate. I wanted to take that line out. That doesn't go well. It's not realistic to believe that it wasn't meant for any other thing but that it was meant for. I just talked in a circle because that's what it is. It was meant for that. Anybody taking an opposition, which Scalia and Thomas apparently are, they're trying to say, oh, no, that's only for talking to your legislators and your president or your governor, executive or legislative body. Oh, so I'm supposed to wait 4 years before I can vote them out. Meanwhile, they're killing people and they won't listen and I can't go to court. That makes no sense at all. Makes no sense. When you have a writ of mandamus, or if you have, let's just take judicial review. Marbury versus Madison, they seem to love talking about judicial review with the power they granted themselves to determine whether something is constitutional. But let me go on. I think I have that at the end here. Courts provide declaratory relief such that a wrong, violation, or abuse by the government onto the people can be declared to the people. Declaratory relief is in the purview of the courts. The courts have jurisdiction over the subject matter, the parties, and the venue. Thus, the courts have an obligation to hear the petition and make declarations or order injunctions or mandates if warranted. Courts are the fora for dispute resolution. That's where you go for dispute resolution, is you go to the courts. If you have a dispute with the government because there's an executive order that's infringing on your rights, or there's an unconstitutional law, where are you going to go? You go to the courts for dispute resolution against the government. That's what they're for. Or your neighbor parking on your lawn or something. And if one or many have a dispute against the government policy or action, then the natural right to petition the government for redress of the dispute relies upon the courts. Else it will be left to righteous revolution against government in response to its wrongs against the people. If an order or declaration from the courts, being a co-equal branch to the executive, if that order or declaration results from a dispute being heard and adjudicated by the court, and the executive branch does not yield to the court's order or declaration. So let's say you go to court, you go through the trial, the motions, and the court says to the executive branch, hey, governor, stop doing this to the people, rescind that order. We're nullifying that order. If the governor does not yield to the court's declaration or the court's order and says, no, we're going to do it anyway, and we have the state police to enforce it, the redress was not for nothing, not for naught. Right? It was not. Here's why it was not for nothing. Because the people are thusly informed of the righteous answer to the dispute. The courts have heard the evidence and they've had a fair balance. You have both parties fighting in court. You have the adversarial process. And in the end, judge makes the fair decision, the just decision. And he declares that to the people. That's important because, well, I'll just say that is the court's answer. An order or declaration after hearing the evidence is a signal to the people whether the challenge of the petitioner plaintiff is righteous. For without that signal from the court, individuals are but mere nomads crying out in a desert or in a crowd trying to be heard as one among 330 million people. To deny that the courts have a role in the right to petition for a redress of grievances is to compel tyranny born from unrestrained, unchallenged power until such time as revolution will solve the tyranny as the courts knowingly withdrew from providing an opinion on the righteousness of complaint against the tyranny. And here's what I was saying earlier. Judicial review cannot coexist with such a denial of the right to petition the courts. So I believe that Scalia and Thomas are wrong in saying that a lawsuit to preserve your rights is not a petition for grievances. You can't go to the courts. You go talk to the legislative branch. No, the courts are there to hear it. And even if the other branch won't do what the court says, at least the court has heard both sides and made an adjudication, made a decision, and that's a signal to the people, because not everybody understands what's going on in the case. The court says, the guy's right. You just killed a whole bunch of people with a vaccine. Maybe you shouldn't mandate it. If they heard all the evidence, that's what they would say. And if the governor said, we're going to mandate it anyway, we don't care we're killing people, we're going to do it anyway, the people will have been informed by the court that the matter was adjudicated after the evidence was heard in a substantive argument, not a procedural argument. And that signal to the people will tell them, maybe you should do something about this besides vote in 4 years after another 100,000 people are dead. Moving on. Now I'm gonna bring you through standing doctrine. Hang with me. This is really tough because I've talked to several lawyers and they tell me that they're going to tell me about standing doctrine, and I listen to them and I'm laughing inside half the time when I'm listening to them. The best lawyers I've talked to said it doesn't make any sense. And they're right. And I agree. It doesn't make any sense. Standing doctrine is a way to kick cases out of court, which I'm going to show you. It's a way for any judge at any time on any whim can take your right to sue somebody by saying you don't have standing, because the defense attorneys have been taught always file a motion to dismiss and always cite Ashcroft versus Iqbal and Bell Atlantic versus Twombly. And 9 times out of 10, the judge will say, yeah, I got to clean my docket. I get too much work, so let's get rid of these cases, which is a violation of what I just read to you, your most foundational right. I just read the whole history of the right to petition for redress of grievances. I didn't even get into the 14th Amendment equal protections and due process of law that you have a right to. So in addition to the first, you have the 14th, you also have the 7th. So it's not matters of equity. If it's matters of law, like a contract or a tort, you have a right to a jury trial from the 7th Amendment. And you have a right to dispute resolution in cases and controversies in Article 3, Section 2. That's what it really says. It doesn't say anything about standing. Yeah, you have called the word standing. It's not in there, but you have standing. You can go to the federal courts if you have a constitutional question, a federal question. Let's go. Let's do this. Part 1, article, I told you, it's not in there. It doesn't say standing. Here's the part of Article 3, Section 2 of the U.S. Constitution that has to do with standing. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States. That's it. That's all. So it's cases in law and equity arising under this Constitution and the laws of the United States. So I told you, the laws of the United States and constitutional provisions, it's either that or there's another section that talks about diversity being in different states. I left it out. But there's nothing here in standing. How you get into federal court and have your case heard is this, else you'll be in state court. So that's one. So from this, I'll show you where they get from this. We're going to go through 7 steps. Step 2, in 1934, they passed Section 2072, which is the Rules Enabling Act. And that allowed, well, I'll just read it. The Supreme Court shall have the power to prescribe general rules of practice and procedure and rules of evidence for cases in the United States district courts, including proceedings before magistrate judges thereof and courts of appeal. Such, I'll get to the B in a second here. This is the rules of civil procedure, rules of criminal procedure. The court can make up their own rules. So if you go to file a lawsuit, you have to do it in a certain amount of time. Where is that defined? It's defined in the rules of civil procedure. How do you serve it? You have to prove that the person received it. Because if they don't show up in court, oh, I win, they didn't show up. Well, you got to prove that they received it, they answered. And so there's this whole procedure going on. And the rules of evidence, there's a lot of rules of evidence. You know, you've heard about hearsay evidence. You have to give notice of those whom you wish to depose. And there's a certain amount of time. So all these rules are, I don't want to say codified, they're made up by the courts. And so they're the rules of civil procedure. This is the act that gave the courts power to make their own rules. B, this is important. Ready? Such rules shall not abridge any substantive right. So a rule of civil procedure should not step on a substantive right, such as the right to petition for a redress of grievances, or the right to due process, or the right to sue and have a jury trial. Such rules shall not abridge any substantive right that is in the Rules Enabling Act. So what did? They made up a rule, Rule 8, claim for relief, a pleading, so a lawsuit, that states a claim for relief must contain a short and plain statement showing that the pleader is entitled to relief. That's all it says. A short and plain statement showing that the pleader is entitled to relief. Step 4, Rule 12. So you hear of 12b6. That's failure to state a claim upon which relief can be granted. So every defense, so basically you file a complaint, they file a motion to dismiss, and they cite Rule 12b6, and they say that you have failed to state a claim. And one of the ways you've failed to state a claim, they say, is you didn't state enough facts. It should be a short and plain statement showing that you're entitled to relief. Why are you entitled to relief? Well, you have to show some facts. How many facts? They don't tell you. It's the subjective whim of the judge to say whether or not you have standing. So we're on step 4. Let's go to step 5. They had about 150 years of disparate rulings as to what standing is across different circuits around the country. And they brought all those together in this case in 1992, Lujan versus Defenders of Wildlife. The Defenders of Wildlife stated that, and Lujan was, I think he was the EPA chief at the time. But Defenders of Wildlife said that the EPA and the federal government was giving money to Egypt to renovate the Aswan Dam. And those renovations might disturb the mating of the Nile crocodile. And if they go extinct because of the renovations on the Aswan Dam, then it will affect the Defenders of Wildlife, because someday they might want to buy an airplane ticket and go there to see the Nile crocodile. That's the lawsuit. I'm not kidding. This is U.S. law. So what the courts did was they used this as an opportunity to create a 3-pronged test to define what standing is, because the legislators never defined what standing is. So the courts took it upon themselves to take the Article 3, Section 2, and then the Rules Enabling Act, which gave them the ability to make their own rules, and then Rule 8, short and plain statement, and then Rule 12, failure to state a claim. And they made up this on top of all that to say whether or not you have standing in 1992. Invasion of a legally protected interest that is actual. So the harm to you has to be actual or imminent, concrete and particularized, and not conjectural or hypothetical. That's an injury in fact, prong 1. So you have to have an injury in fact. And then traceability. There must be a, quote, causal connection between the injury and the conduct complained of. So the injury that you have has to be from the act of the defendant, meaning the injury is, quote, fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party not before the court. The key word there is independent action. So if it's a dependent action, in other words, the law school threw me out, but was their act independent of anything from the state that I'm suing? No, it wasn't. In fact, it was directly resulting from. They instituted the mandate, they said, because the state told them there were 20,000 deaths from COVID in Massachusetts, and the vaccine was safe and effective. Those two things are fraudulent. They lied about all but 90. They lied about 90% of the COVID deaths. They weren't from COVID. And the vaccine deaths, they were hiding. So it's not an independent action of the law school to throw me out and have a vaccine mandate. The vaccine mandate was not independent. It was based upon the fraudulent information from the state. But for the state's lies, the school would not have enacted a vaccine mandate. Redressability, likely as opposed to merely speculative, that the injury will be redressed by a favorable decision. In other words, if I go to court and I win, what do I get? Can the court redress the injury? Can they fix it? Can they order the defendant to pay me money? Can they order the defendant to let me back in the law school? If there's no way for the court to redress the injury, then what's the point in hearing the case? The court's busy. So that's why the redressability is in there. This three-pronged test lasted for 15 years. It still lasts today. It's still good. They use it all the time. But they added to it. And I'm going to tell you two more cases that they added. Bell Atlantic versus Twombly in 2007. Plausibility. This is the plausibility per Rule 8A2. Remember, short and plain statement showing that I'm entitled to relief. So they added language that is very often cited. And that language is, factual allegations must be enough to raise a right of relief above the speculative level, on the assumption that all the allegations in the complaint are true, even if doubtful in fact. In other words, the facts that I wrote in the complaint and listed as facts, they have to take those as true. Those being taken as true, is it more than mere speculation that the defendant wronged me? So the judge is making that decision based on this Bell Atlantic Twombly. Plausible claim for relief. Another quote from the case: asking for plausible grounds to infer an agreement does not impose a probability requirement at the pleading stage. It simply calls for, and here's what's required, enough facts to raise a reasonable expectation that discovery will reveal evidence of illegal agreement. And they're saying it's not a heightened pleading standard. So they're saying it's not any more than was done before. It's not an added heightened pleading standard. It's the same as always been there. We do not require heightened fact pleading of specifics, but only enough facts to state a claim for relief that is plausible on its face. The plausible on its face is a big one. So it's not a heightened pleading standard. Yeah, right. I'll show you how it's not a heightened pleading standard, how much this case was used. Okay, the last one. Ashcroft versus Iqbal. Iqbal was arrested in New York City just after 9/11 on a green card violation, thrown in prison, beaten up, deported to Pakistan, and he sued for being beaten up. But he sued all the way up to Ashcroft, Attorney General John Ashcroft, who was the Attorney General at the time under W. Bush. And it referenced Bell Atlantic versus Twombly. And you're going to see, I call this twickball. People have been, it's a portmanteau, by the way. When you take the front half of one word and the back half of another word and you munge them together, it's a portmanteau. Portmaneau, French word. Plausibility standard. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. That's quoting Twombly that I just told you, right? The plausibility standard is not akin to a probability requirement, but it asks for more than a sheer possibility that a defendant has acted unlawfully. And this I see all the time. All three of my lawsuits that I did, they put this in. Threadbare recitals of elements of a cause of action supported by mere conclusory statements do not suffice. Mere conclusory statements. The vaccine killed her. I mean, it killed her. It's not a threadbare recital. I have facts in there. These are not merely conclusory. They're not threadbare recitals. I have facts. Even the doctors agree on Brianna. They lied about her death record for 3 years. I meet all these standards easily, and yet they won't even hear it. They can't let me in court, so the whole narrative crumbles for the entire world. So there's a two-prong approach. Some people say the first is the tenet that the court must accept all the allegations as true contained in the complaint. Second is only a complaint that states a plausible claim for relief survives a motion to dismiss. So there's that plausible again. Is it plausible? Is it plausible that the vaccines are killing people? No, because vaccines are the god idol of this heathen state of Massachusetts that doesn't believe in God. Unless you go to, they have gods that they believe in up in Salem, they believe in Satan. the Satanic Temple of Salem. They loved that. It's in the center of the town, right near the court where I went there. They have a little garden, and then the garden is sponsored by the Satanic Temple Salem. I guess they're proud of that in Salem. Nobody's taken it out. So here's a bonus not often remembered from Iqbal. I found it to be very important, and I totally forgot or didn't know about it, never really paid attention until I read it this time when I was making this presentation. Determining whether a complaint states a plausible claim for relief will be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. What does that mean? That means he's acting in equity. That means the court, the judge, is acting in equity. He's relying on his judicial experience and common sense, not the law. He has to follow the law when there is a law, but when there's not a law and there's something nuanced about the case, he has to draw on his experience, common sense, in fairness. That's what equity means. You're either in law or in equity, right? Did I do that yet? I think if I didn't do it yet, I'm going to get to that in a minute. So what they're saying, as a quote from Iqbal, they're basically saying it's an equitable decision. They're not saying in the words it's an equitable decision. They're saying the judge has to draw on his judicial experience and common sense. It's very important because that's part of my, it will be part of my petition for writ of certiorari. So here's the path to standing doctrine. You have one in white there, Article 3, Section 2, that abstract language that didn't say anything about standing. And then you go to the 28 U.S.C. Section 2072 Rules Enabling Act in purple down bottom. Make your own rules, courts. And then number 3 in blue, the Federal Rules of Civil Procedure, Rule 8, which is rather abstract, a short and plain statement showing that you're entitled to relief. That's it. That's all it says. 4 in green, Rule 12b-6. Failure to state a claim upon which relief can be granted. And then you have Lujan versus Defenders of Wildlife with the 3-pronged test, injury in fact, traceability, redressability in yellow. Twombly, which is the Bell Atlantic versus Twombly, you need to plead sufficient facts in orange. And then in red, Iqbal, it has to be plausible on its face. So somehow the attenuation of authority, the authority the courts have, is to hear a case that has to do with the federal law. That's one, and it's pure and it's white. You go through all these gyrations. Make your own rules, court. Okay, we'll make these 2 rules. Okay, from those 2 rules, we'll make a 3-pronged test. Okay, in the 3-pronged test, we're going to add a little bit more abstract prose and sufficiency, and then it's plausible on its face. What they've done is they've created a way in which any judge at any time can dismiss any case for anything. That's where we are. I told you I was going to tell you law and equity. I think this is important to understand. People, they think, you go to court and it's the law and that's it. Oh, well, no, we're a common law kind of nation. We don't codify everything. So a lot of stuff is left up to the judge to adjudicate in fairness and equity. So if it's not at law, it's in equity. The courts of law, so a court of law, it's strict adherence to the precedents caused remedies without fairness. Or equity. So that means, I'll explain that. When they strictly adhered, if a court strictly adhered to precedent, the common law, what has happened in the case before, we have to do the same thing in this case too. But wait a minute, there's nuances, there are small differences in this case. Who cares? We have to do what was done before. Okay, so that's not fairness. That's not equity. You're not being fair because there are extenuating circumstances. The person was lied to. There's all kinds of other things that can be brought in. So the Court of King's Bench was formalized in 1178, and that's a court of law, common law. The Court of Common Pleas, also a court of common law, was for civil disputes, English common law, precedent and custom, rigid legal remedies. So you get these rigid courts, and the exchequer of pleas. The Normans were coming over all the time and beating up on the Saxon, the Anglos. So you have this influence of the French with the exchequer of pleas, initially for revenue disputes, then for broader civil matters. So you see now you're starting to see like competing courts. You have a matter with your neighbor. You want to go to a court? Where do I go? I got all these different courts. So they established the courts of equity a few hundred years later, like 200 years later. It was formalized in the 15th century, but I think it was established in the 14th, headed by Lord Chancellor. So each court was the judge was called the Lord Chancellor. It's called the Court of Chancery, and we call it the Court of Equity. And these were principles of equity, fairness, okay, injunction, specific performance, and trust enforcement. But there was a conflict. In the 17th century, the courts, which court has jurisdiction? Your common law courts, like all those other three I mentioned, the King's Bench and Common Pleas and the Exchequer of Pleas, versus the Court of Equity. Who wins? If somebody goes to one court and the judge says, well, I'll just read it to you. The Earl of Oxford's case, 1615, King's Bench Chief Justice Coke overturned a jury verdict. So the jury gave a verdict and the judge said, no, I'm going to overturn that. Well, Lord Ellesmere, Lord Chancellor Ellesmere, that means he was the head of an equity court of equity. He enjoined the enforcement of Coke's order. He said, no, you're not going to do that. You're not going to overturn that jury verdict. So you have a stalemate between the courts. This was brewing, right? You have competing court systems. So Ellesmere appealed to King James I. King James I referred the matter to Sir Francis Bacon. We've heard that name. Well, I mean, I have. Attorney General for England and Wales, and another guy who was the Attorney General for the Prince of Wales. Both Attorneys General agreed to find in Lord Ellesmere's favor, which King James approved. The holding, okay? The cause why there is chancery is for that men's actions are so diverse and infinite. In other words, our actions are so diverse and infinite, we can't have a law for every little thing we do, that it is impossible to make any general law which may aptly meet with every particular act and not fail in some circumstances. So no matter what law you make, there's going to be a failure of that law if you measure it against fairness and equity at some point. So that's why they found in Lord Chancellor's favor, Ellesmere's favor. So the Supreme Court of Judicature Acts of 1873. We're getting up there, right? I mean, this is approaching 1900. Don't forget. I mean, we're the 1873 and 1875. The courts in England were like, why have these stalemates between the courts where the King's Attorney General has to decide? And even though from that case I just told you, it became known that the Court of Equity was more powerful and would take, I don't want to say precedent, would basically almost subjugate the King's Bench court, common law courts. So what they do in 1873 and 1875, they merged the Supreme Court of Judicature. So the Court of Chancery, that's the Court of Equity, Court of King's Bench, common law, right? And the rest are common law. The Court of Common Pleas, the Court of Exchequer, the High Court of Admiralty, the Court of Probate, the Court of Divorce and Matrimonial Cases. They combined all their courts, the Supreme Court of Judicature Act. The objectives were to merge the courts of common law and equity. So instead of having two different courts, you have one court where you go in and the matter is then at law or in equity. To create a uniform system of pleading and procedure. No two different procedures. You don't have 30 days to do something in one court and 45 in the other. And to enforce the same rule of law where common law and equity had different rules. So the United States, we inherited the English system of law. USA followed England's lead into merging courts. So we merged our courts too. We came up with federal equity rules of 1912. It's no longer in effect because it was replaced by the Federal Rules of Civil Procedure, the Rules Enabling Act of 1930 something I told you about. Is it 35 or 38? It's on the other slide. Rule 8, short and plain statement, flows from the Federal Equity Rules of 1912. That's where it was first written. So what do we have now? Now our courts are unified tribunals of law and equity. The distinction is now substantive, whether a remedy is at law or in equity. For example, contracts and torts have damages and compensation, compensatory and punitive damages. That's at law. and you have the right to a jury trial under the Seventh Amendment for those type of actions. But for a matter in equity, such as unjust enrichment, or you have an immediate irreparable injury, your neighbor has infringed on your property, and it's all your grass is going to die. It cost you $5,000 to have your lawn put in. It's not getting any sun because their whatever is laying on your grass. Get that thing off my grass. I can't even lift it. So you're asking the court, it's an immediate irreparable injury. My grass is going to die unless you order him to get it off. So there's restitution damages, specific performance, injunctions, declaratory relief. So you hear about injunctive and declaratory relief. You're asking the courts to order somebody to enjoin them from doing something. So stop doing something, or to do something that they should be doing. You don't have a jury right in equitable matters. So you bring the same lawsuit, you bring a lawsuit to the same court, same judge, and the judge is either acting in equity or law, depending on the type of matter you brought. That's how it works. So the court of equity, so equity means it's beyond the law. He's got to make a decision in fairness. And that's the argument I'm making with regard to going to the Supreme Court for my case. Whether or not I have standing is a matter of equity. And in being a matter of equity, I'm going to recommend that they fix the standing doctrine, the standing doctrine, fix the doctrine, add to it what is done in equitable matters, which is having a balance of harms and a balance of the parties and the public interest. Is it in the public interest? If the court gives me a favorable decision, is it going to kill a lot of people? Right? You got to balance the harms and figure out whether or not it's in the public interest. If they did that in my case, they would have heard the case and I would have standing. I'll show you how many cases are bad. So now here's the management systems analysis that maybe you've been waiting for. Hopefully more people will watch this later. The management systems analysis of standing doctrine. You ready? This is the number of civil litigation filings each year for 30 years in federal district court. Do you see what happened in 2020? There's an overwhelming event. You don't see a single number above 300,000 for 25 years. And then in 1 year, it went to 470,581. And in 21 is pretty substantial, and 23 is pretty substantial. But 2020 is ridiculously high. This is standard deviations above mean. This is z-scores. So when Ed Dowd talks about a 10 sigma event and something that's a 5 sigma event, it's like very improbable that it will ever happen. This is 13.57 sigma, 13.57 standard deviations above mean. This is an overwhelming event. What do you do with it? And what are the numbers? Okay, it's 180,000 extra cases in 1 year that came in, 180,000. What do you do with them? This breaks the system. And if you look at it from a percentage viewpoint, it's 62%. The reason why all these little gray boxes for 25 years are small is because it's pretty deterministic how many cases actually come in to the courts. And there's some variation. This one is 5.7%. Wow, that's big. This is negative 6.3%. Those are the two ends. Positive 5.7 to negative 6.3. And then you have 62%. Did they hire 62% more people in 2020 to handle the caseload? Did they work 62% more hours? I don't think they were working, instead of an 8-hour day, I don't think they were working, what would 62% more be? I don't even know. 14.8 hours in a day instead of 8? I don't think they were doing that. So what did they do? What do you do with an overwhelming event? Start tossing cases and dismissing them, right? So now here's another analysis. These are the citations of the most popular, most cited cases in the United States history. Most of the ones that I could find anyway. So Roe v. Wade was 51,000 citations. Griswold versus Connecticut, 39,000. Buck v. Bell, 8,600. Marbury versus Madison, a big constitutional case that everybody cites, 38,000. I'm going to start skipping. right? New York Times v. Sullivan, 34. Here's Miranda. Everybody knows about your Miranda rights, right? 88,000. It's pretty big. But then let's just skip down, all the way down here, and you get to Lujan versus Defenders of Wildlife. That's a standing doctrine case, 44,000. Friends of Earth versus Laidlaw, 12,000. These are standing doctrines down here, these last six. Now look at Bell Atlantic versus Twombly and Ashcroft versus Iqbal. That's crazy. Why were these cases from 2007 and 2009 cited more than any other cases by far in multiple? This is unprecedented in U.S. history. These cases are only used in a motion to dismiss based on standing. It's the only thing they're actually, Ashcroft versus Iqbal, I believe, is used in qualified immunity sometimes, but same thing. You don't have standing. He has qualified immunity. You're out. Same kind of deal. 300,000 times. So this is per year. If you look at it on a per year basis, because Twombly and Twickball were 2007 and 2009. 16,000 and 18,000 times per year they've been cited. You see the rest of them. The other biggest number is 1,700. I could have sworn something was bigger. I don't think I left anything out. These other cases have been around a long time. They're the seminal cases in the history of law in the United States. These cases are cited all the time. But look at Bell Atlantic and Twombly. So the organizational behaviors, the cause, overwhelming workload event, all these cases flood in. You have, I showed you that you had 180,000 excess cases in 1 year. What happens when that floods your workload? You have formation of habitual deferral culture. In other words, you're going to defer your work by dismissing. And standing doctrine shows that standing doctrine was used to get rid of cases. It was happening before 2020. Yes, I would love to see the curve. I think it went sky high when 2020 came, but I don't have access to the information. I just have a total number and the year, and then I divide by the number of years since it happened. So let's, I only have like 2 slides left. What time is it? 9:18. I'm going to go through organizational behavior theory, and I'll probably just end up reading some of this stuff. But from it, you'll understand. You'll understand what happened to the courts in the last 5 years. It's been far worse than people can imagine. And this applies not just to the vaccine and cases like that. The elections, transing kids, climate stuff, the border disputes, everything where you bring a case is being dismissed. The courts are not hearing the cases because it's become a habit. They're overwhelmed. Let me read through these. You'll see what I mean. These are behaviors of avoidance, deferral, and procrastination. So the habit loop model by Charles Duhigg. Procrastination becomes habitual when cues trigger deferral routines, rewarded by temporary stress relief. So you're rewarded by get the case off my desk. So your deferral routine that you're creating is motion to dismiss. Okay, allowed, case dismissed. Failure to state a claim. Not enough facts on the face of the complaint. They're saying you're Rule 8 and your Rule 12b-6, you're out. You don't have standing, you don't have standing, you don't have standing, you don't have standing. If it worked once and it works again and it works again, you just keep doing it. It becomes a habit. So that's the habit loop model. Conservation of resources theory, core theory. Employees defer work to conserve cognitive or emotional resources when faced with stress or high demands, leading to habitual avoidance. This one fits what happened very well. You have a high demand that the clerks and the judges are facing. 62% increase in 1 year. It leads to the habitual avoidance. When you do something once, it's a one-off. You do it twice, it's starting to be a pattern. You do it 3 times, it's a habit. What if you do it 100 times in a year? Over and over and over. That you think you go into the next year and you're just not going to do it anymore? No, you're going to rely on the same cases and you're going to do the same things you did. Dismiss, dismiss, dismiss. But even if you don't have the 62% increase in caseload, the behavior and the habit has been embedded in you based on the workload. So the core theory really applies. Social exchange theory, if employees perceive low organizational support, they may procrastinate as a form of disengagement, forming a bad habit of procrastination. That means, you're not getting any attaboys at work. You go to work, do the same thing every day, and nobody says good job. Nobody says bad job. Nobody says anything. Your work just degrades to the point where you're just scraping by until somebody says something to you. So you work to the lowest standard you can. Social learning theory, that's from Albert Bandura. Oh, I didn't say these are from The Power of Habit, Why We Do What We Do in Life and Business, Conservation of Resources, a new attempt at conceptualizing stress, social behavior as exchange, and now Albert Bandura's social learning theory. He actually named it, the book, as to what this is. Employees observe and mimic behaviors modeled by peers or leaders. So he's just saying you're doing what everybody else around you is doing, and so it becomes your habit, but you're just mimicking what others are doing. Reinforcement theory, positive reinforcement can inadvertently strengthen low effort habits, even if they undermine long-term goals. In other words, when I gave presentations about the accounts that I was working on, the deals I was working on, I worked on some pretty big deals. And I never liked to let management know what I was doing. I played it close to the vest. I had my engineers I worked with, they worked for me, and they made sure my accounts were happy and they delivered what I told them to deliver. But I gave these presentations that I thought were terrible. I wouldn't put any effort into it. And at the end, they would always say, "Oh, it's a great job, John. That was a great presentation." I'm like, "What are you talking about? I did this in 5 minutes at my desk. I didn't put any effort into it at all." So that's what this positive reinforcement can inadvertently strengthen low effort habits. And people who like me would say, "Oh, John, stop. Don't say that about yourself. Don't be negative." I'm not being negative. I didn't put time into those on purpose because I didn't want to let management know what I was doing because they would undermine it. A lot of them were dumb. I was told not to do things that I was told not to bring it, not to even work on an account that now has brought in over $1 billion in revenue. Over $1 billion. Would not have happened if I listened to the VP. I did the right thing for the company all the time. Back to this. Here's the most important one. Ecological systems theory from Uri. Oh, I didn't tell you the reinforcement theory. That was B.F. Skinner, by the way. So B.F. Skinner, I mean, anybody who went to high school in the 70s, 80s, probably the 60s, everybody's heard of B.F. Skinner. Science and human behavior. So that was a good one, the reinforcement theory. Ecological systems theory, Uri Bronfenbrenner. The ecology of human development, experiments by nature and design. Overwhelming work environments create conditions where bad habits become the norm as employees adapt to survive. Does that sound like the district courts in 2020? 62% increased load? 180,000 excess cases, more than normal? Overwhelming work environments create conditions where bad habits, dismiss, 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 become the norm as employees adapt to survive. So, by the way, that was 1979 from Uri Bronfenbrenner. So you have 79, 1953, 1958, 1989, 2012. I mean, I like a lot of these. I'm older. Maybe it's because I knew a couple of them from before, from psychology in college. And I took like 5 or 6 psych classes in college. I liked it. And sociology. These are important to me, and I thought they were a good fit for the conversation, especially with organizational behavior. What's happening now is people think they have to be published, so they're publishing a lot of garbage. They're trying to undo somebody else's theory just to undo it so they can get a claim for themselves. They're all just theories. Nothing fits perfectly. These are all models. All right, Holland. This was from Breaking and Creating Habits on the Work Floor, a field experiment on the power of implementation intentions from the Journal of Experimental Social Psychology. in 2006. To break habits, so this is now, I think I'm going to get into more proactive stuff of what can be done for the courts. To break habits like procrastination, planning new behaviors to replace habitual deferral significantly increases desired actions. So if you plan it, you'll do better than if you don't do anything. Conscious planning can disrupt deferral habits. We don't want deferral habits, right? We don't want them to defer work. Just do your work. Hear the case. Hear the case. Hear the case. Hear the case. Not dismiss, dismiss, dismiss. Conscious planning can disrupt deferral habits by making alternative actions the path of least resistance. This applies to workplace procrastination, where deferring tasks becomes habitual due to immediate relief. Well, if anybody has any questions, pop them in there. I'm going to read questions after. I'll go through the whole thing. 2007, procrastination often becomes habitual because deferring work is cued by stress or task complexity and rewarded by short-term relief. Dismissed, relief. Dismiss, dismiss, dismiss the cases. Standing, standing. Reinforcing the behavior. Okay, habits favor effort minimization. That's how you form a habit. You minimize the effort. Habit, you minimize the effort. As individuals gravitate toward behaviors requiring less cognitive or physical effort, habits driven by deferral are resistant to change because they are automatic and context driven. Once the habit becomes automatic, 2020, dismissed on standing, not enough facts, not enough facts, plausible on its face, plausible on its face, habit, habit, habit. Everybody's dismissed. Every single one of those should be weighed against your right to petition the government and your due process rights. But they didn't do that. And I'm going to propose that they need to do that. Lally in 2010, How Are Habits Formed? Modeling, and they spelled modeling. This guy might not be from the US. Maybe that's an English spelling of modeling. They use two L's. Should be one for the US. Modeling habit formation in the real world from the European Journal of Social Psychology. Habit formation through daily repetition, simpler behaviors forming faster. Form faster. Rewarded by temporary stress relief. Yeah, same stuff as before. Behaviors requiring minimal effort form habits faster. Yes, I already wrote that. Deferral behaviors can become entrenched if not disrupted. Okay, there you go. The courts are running, they're managing, the Supreme Court's managing the other courts, right? If they don't disrupt the deferral behavior that occurred during 2020, then it becomes a habit. And it did become a habit because these guys have never taken classes in organizational behavior. They're just running the courts and they don't see what's happening to the system. And I see what's happening to society in the last 16 years since Ashcroft versus Iqbal. There's a breakdown in civil society. There are riots in the streets. There's people getting killed, being pushed in front of subway cars. Justice is not had in the courts. And so it's being had in the streets. It's not justice, though. You have people being killed unrighteously. What else? Entrenched organizational habits, including procrastination and decision-making, contributed to the failure of two companies. This is from Amoa. Old Habits Die Hard, A Tale of Two Failed Companies, an Unwanted Inheritance, from the Journal of Business Research. Deferral of critical actions became habitual due to repeated avoidance of complex decisions. I'm going to have to highlight this one. Ready? I'm going to read this again. Deferral of critical actions became habitual due to repeated avoidance of complex decisions. And then that was 2014. And then in 2022, Verplanken, Habits, a Review and Theoretical Integration. This is in the Annual Review of Psychology. Procrastination becomes habitual when repeated in response to cues like task difficulty or stress of 62% increase in workload, reinforced by avoidance rewards. You're rewarded by avoiding the work, by dismissing the cases. Habits form around behaviors that minimize effort. Habits are context-driven and require stable cues and rewards to form. To break bad habits, disrupt cues, and introduce rewards. One more slide after this. That's it. District courts, OB culture resulting from Twickball, behaviors of avoidance, deferral, and procrastination. So the ecological systems theory fits the U.S. district judges and clerks. And let me read that again. Overwhelming work environment, bad habits become the norm, and the employee adapt to survive. So you've got overwhelming work environment that causes bad habits that become the norm so that the employees can adapt to survive. So the U.S. District Court judges and clerks had an extra 180,000 cases, 62% increase in 1 year, and the habits that formed were dismissal, for lack of standing, and failure to state a claim. For the civil litigation defense attorneys that submit the motion to dismiss that allows the courts to use to dismiss based on standing and a failure to state a claim, it's less work. They have 4 rounds of filings. They're getting paid. They don't even have to go through discovery. They don't even have to come up with discovery questions. They're not even there yet. They're in the pleading stage. The plaintiff files a complaint. The defense attorney immediately files a motion to dismiss, cites Lujan versus Defenders of Wildlife, 3-prong test. They cite Ashcroft versus Iqbal, plausible on its face, and they cite Bell Atlantic versus Twombly, sufficient facts. And they're getting paid for reading the complaint, filing the motion to dismiss, reading the opposition memorandum, filing the reply brief. I think I got all that right. So this is learned behavior. This is reinforcement theory for the lawyers. And let me read that one. Reinforcement theory. Positive reinforcement can inadvertently strengthen low effort habits. So they're forming a low effort habit of motion to dismiss, motion to dismiss, motion to dismiss, because they're getting positive reinforcement for it. And lastly, everything I'm talking about is federal courts. Unfortunately, the states copy what the Fed does. And all the states, well, I don't know about all the states. Massachusetts has copied the whole standing doctrine thing, almost verbatim, which is crazy. And here's why. The federal courts should have some type of standing requirement because you have to be in either diverse in different states, or it has to have to do with the federal law. That's how you get in a federal court. Otherwise, the courts are really supposed to be in the states. Your contracts and torts and state law claims should be in state courts. Now, if you have a standing requirement in the federal courts and the states copy it, even though they're not Article 3, Section 2, right? They have different, each state has their own constitution. Where else are you going to go to get justice? If you can't go into the federal court, you can go into the state court. But if you can't go into the state court because they make up the same BS standing argument that the federal courts made, where are you going to go? The states are just doing a copycat. It's, what did I write here? Disease in state courts. I don't know what I think it's become a disease that metastasized into the state courts. Maybe that's what I meant. These are just my notes to myself. I'm pretty much done. Yeah, the states shouldn't copy the Fed in standing. Standing is meant solely for the federal courts, or should be only for the federal courts. Where else are you going to go to get dispute resolution if you can't go to a state court or a county court? What are you going to do? But I'm going to read the questions if people still have them. Let's see what we got here. Oh, hardly anything. Wow. Oh, that's a slow day. Question: do you see evidence that possibly the insane increase in false load for the courts was an intentional plan by Mr. Global to water down the justice ability? You know, I never thought about that. I thought of it as when 2020 came. I mean, I had never filed a lawsuit in federal court, but I did. I filed a case against the governor for the mask mandate. So if I was doing it, maybe a lot of other people were doing it too. Yeah, no, I think that 2020, my own opinion, I think it had more to do with when they created all the COVID orders, they were flooded with lawsuits. Think about all the orders. They said that they were trying to say people didn't have to pay their rent, that people who owned property had to defer their rent charges up to their tenants. Can't do that. That was a lawsuit that happened in March, I believe, of 2020. For every one of the COVID orders in every state, there were lawsuits, and those lawsuits were brought in federal courts because they had to do with violations of your constitutional rights. There's never been anything like that in the history of the United States. What they did to us in 2020, people were bringing lawsuits left and right. They were using their life savings to bring lawsuits. I think it was more to do with that. I don't think it was an intentional increase in. Although they are pretty smart, you might have something there. They are pretty smart. Do you have evidence of the classification of the intense percent of cases by subject? No, I don't. Top lawsuits: immigration, transgender, pro-life, mandatory vax, layoffs, and discrimination. No, I'm sorry, I don't. I just looked at total civil cases. They break it down civil and criminal. And they do have like civil US or not US. In other words, the parties are, neither party is the government or one party is the government. So they break it down that way, but I did not see a breakdown. I think on the table, if you read it, what does it say? Table C8, U.S. District Courts, and then I have U.S. District Court caseload statistics data tables found at uscourts.gov/statistics-reports/caseload-statistics-data-tables. That's where I found the information. Chevron deference collapsed. Yes, thank God. I know that is why I am thinking maybe part of the plan, Mr. Global. Yeah. Yeah, the globalists sure are controlling a lot. I don't know. Does anybody, if there are no other questions, we can probably, oh, hi, Alicia. Hi from Dallas. Good to see you here. This is really bad. I don't think people understand how bad this is. These cases are not being heard, and they're leaving Americans to be confused as to why did I lose? Why did my favorite person's case not make it even to discovery? I believe it's purposeful. So, okay, I know a good answer to this Mr. Global question from local prolifern. Do I want to say this publicly? So John Roberts came in 2005. And in 2007, you had Bell Atlantic Twombly. In 2009, you had Ashcroft-Iqbal. And from that point on, regular people didn't have standing in courts. You'd have to be rich, or you'd have to kind of know what you're doing. And I didn't know what I was doing. I had a guy that I played soccer with in the over 50 soccer league. I said, hey, do you have any cases? And he said, yeah, we just won a case. Like, can you just send me the file? Oh yeah, it's a public file. So he sent it to me, and I used that as a template and just copied it. And I swapped out their legal theories for mine. And I said, you're depriving the governor with his mandate for the masks. He's depriving me of receiving free speech from other people because he ordered them to cover their mouths, and I need to see their lips move in order to hear. They were afraid of that. They were really, because it's a constitutional violation, freedom of speech. I mean, really, a really good case. So what did he do? They deferred, and they didn't defer. They asked for an extension, asked for an extension, asked for an extension. I said, yes, yes, yes. The longer it went on, the more people hated masks. And the more people hated masks, the better it was for me. Maybe the judge would hate the masks. But in November, they finally filed a motion to dismiss, because a week before they filed the motion to dismiss, the governor rescinded Order 31 for masking, when he reissued Order 55 with an exception in paragraph 2B. And paragraph 2B said, buyer between either party being hearing impaired, they don't have to wear a mask. So if you're hearing impaired, you don't have to wear a mask. And if you're speaking to somebody hearing impaired, you don't have to wear a mask. That is a legitimate standing argument. I no longer had a complaint. I had nothing to complain about. But I did. I can argue anything either way, right? So that it is legitimate in that case. However, what I wrote in my opposition memorandum in the motion to dismiss is, I'm stepping into the road in front of a bus. And the guy on the other side of the street waves his arms, and I look at him while I'm stepping in front of the bus. And he says, look out for the bus. But I can't tell what he said because I don't know what he said. He had a mask over his face. How are you gonna handle that, court? You know, you gave me an exception, but I can't hear the guy because I'm deaf in one ear. So anyway, that's the whole thing. I made it through this whole thing standing. I'm standing at my desk. So whoops, I'm going to trip over my chair. I have a lidocaine patch on my back that a friend of mine gave me, and I don't feel anything. This feels pretty good. You know, I can understand why people take drugs. I don't take hardly anything. that same person is going to try to get me to take vitamin D. She's been trying for 4 years or 3 years to get me to take vitamin D. Like, I don't take anything. It's a drug. I'm just kidding, everybody. Uh-oh. What did somebody write here? I had a lawsuit in 2020, had nothing to do with COVID, but was not heard in state, but federal as lawyer recommended instead of state filing. Well, that's interesting. Most defendants want to be in federal court. Okay. And lawyer deserted and lied in my case. I appeal $100,000. I mean, an appeal would be $100,000 when I asked another lawyer about appeal, so left it as it was. Yeah, they get you that way. That kind of sucks. You know, my appeal cost me $600 because I wrote it myself, and now I'll be writing my petition for writ of certiorari. So 2,000 years of try acupuncture, 2,000 years of acupuncture. Oh no. Oh no. I dated an acupuncturist for a few weeks. A few weeks. Yeah. I won't get into the details, but she never did acupuncture on me. So that I'll tell you that. All right, everybody. Thank you for hanging in there with me. You know, hopefully sections of this can go out to prospective law students because I don't think a lot of them get this kind of education. I didn't. These were much of what I'm discussing here were in paragraphs and footnotes that people skip over because they're just reading the cases that they have to brief. They don't read, like, what's the history of the law and the formation of the law. Joe did a very good job. That's OsirisSoft on X. Did a very good job capturing part of a Twitter space where Nurse Michelle, a friend of mine, asked me to come in, and so I went in. These are psychological operations people who are trained, and I'm guessing probably pharma, but still could be 77th Brigade, although she's not English. Could be U.S. military intelligence psyops, but I think they ramped back. So I'm just guessing it was pharma. Anyway, that's all trained. So Joe took snippets from the recordings and he posted them on X. So if you're on X, look for OsirisSoft and you'll find those. Hopefully I did okay. I talked about my third grade teacher, Mrs. Brzezowski. I think all us third graders at 8 years old had a crush on her. It's probably because she was the only teacher who wasn't a nun. And all the nuns were Polish, and maybe two of them weren't obese. So, all right, everybody. Thank you much. I'm going to close it down now. Appreciate it. Have a good one, everybody. Bye-bye.